today. And yeah, this particular presentation will be recorded simply because of load shedding. We don't know when it's going to suddenly happen. They haven't given us any time details. So Melissa, has, you know, from your profile, I can see that you are much of tough woman when it comes to real employment equity law, as well as being in the forefront, fighting for the right conciliations and mediations and whatever it is. So, Melissa, is it Cogger? It's more the Afrikaans word, Cogger.
That's Cogger.
Yeah, Cogger. She's just to introduce her to welcome listeners. Just to introduce Melissa, she's a senior associate in the Cape Town Office Employment and Benefits Practice at Bowmans, South Africa. And Melissa specializes in employment law and has a range of experience, as I mentioned, in employment law matters, in addition to dispute resolution. She routinely appears in the Commission of Consultation, and I'm sure that must be a bit of a tough one. I have been in a few, and it's not that easy. Mediation and arbitration, the CCMA and the Labour Court as well has internal disciplinary proceedings. So Melissa has an in-depth experience and routinely advises on complex employment-related matters, including restraints of trade, retrenchments, transfer, sexual harassment, collective bargaining. I don't know much that can be done with collective bargaining these days, including interdicting unprotected strike actions and organizational right disputes. That too, I doubt much we can do, but I'm sure being so tough, you must be walking through that. Yeah, protected disclosures and data protection and equality issues within employment law. She has been involved in a number of investigations into allegations of serious misconduct concerning senior executive employees, sexual harassment investigations, as well as the debarment of key individuals or representatives in terms of the Financial Advisory and Intermediary Service Act 37 of 2002. So Melissa is an executive committee member of the South African Society of Labour Law Lawyers for the Western Cape chapter. Congratulations for that, being Women's Month. I must say you have really climbed the ladder on the women front. And of course, Melissa is a lawyer, completed a LLB and LLM in labor law at the University of Witwatersrand. Well, I have just mentioned all her qualities as to what she's been doing thus far. So now I present Melissa to you, ladies and gentlemen, and I'm sure it's going to be very exciting because her topic is so relevant in the sense that the Employment Equity Bill, well, it's not an act yet. How does it, what should I say, matter as far as the businesses are concerned? You know, where does it fit in there and how are they taking it? I'm sure not well, but it's all for you now. Thank you so much for coming over.
Thanks very much for having me. Would you mind sharing my presentation, Amina? Thank you so much.
Melissa, just to tell you, I'm Fawzia Peer. I am
Fawzia.
Vice President of Minara Chamber.
Thank you very much. Thank you for the introduction and happy International Women's Day to everyone. Yeah, so the topic of my presentation today is the Employment Equity Act Amendment Bill. There are a number of proposed amendments to the Employment Equity Act, but my presentation today is going to focus on some of the more notable amendments or controversial amendments to that bill. You can just go to the next slide, please. So where we currently are in the process in the legislative scheme is that the bill is currently under consideration by the National Council of Provinces. The amendments were tabled back by NEDLAC during 2017, so we are some way into this process, and the Employment Equity Task Team commenced negotiations on the bill in October 2017 and concluded its work in 2018. It was then published for comment in all 9 provinces during October 2018, and there was a series of engagement with the public to comment on the bill, and I will discuss some of the comments made by specific sectors in the industry on some of the amendments to the proposed amendments to the bill. So it's currently transmitted to the NCOP for concurrence. It can either be passed by a majority of votes in the NCOP, or if the NCOP doesn't pass the bill, it will then be passed by the NA, and it will take into account any proposed amendments by the NCOP. And then once it's passed, the last step is for the president to sign it into law. So it's not yet in law, it's still in the legislative stages. And it is still likely, now that we've finished the consultation process with the public, it's likely that it's going to be enacted in the foreseeable future. But before I go into what the proposed amendments are, I thought it'd be useful just to give a very brief overview of what the Employment Equity Act is and why it's relevant to employers. So the Employment Equity Act deals with affirmative action, and it applies to designated employers, and the beneficiaries of affirmative action are people from designated groups. So a designated employer is an employer who has more than 50 employees, or it could be an employer that has fewer than 50 employees, but the annual turnover is equal to or above a prescribed turnover that's set by the minister, and that's a schedule to the Employment Equity Act. So if you want to find out if you're a designated employer, you determine what category or sector you fall into, and if your annual threshold exceeds the amount or is equal to the amount set in the schedule, then you would be a designated employer, and then you would be required to comply with the affirmative action measures contained in the Employment Equity Act. Now, the beneficiaries of affirmative action are designated groups. So that's people, that's Black people, which are further defined as African, colored, and Indian people. And it's also for women and people with disabilities. So designated employers have a duty to implement affirmative action measures for people from designated groups. And this is to ensure that suitably qualified people from designated groups have equal employment opportunities and are equitably represented in all occupational levels in the workforce of a designated employer. So the employer needs to consider what the measures it will take to identify and eliminate employment barriers which adversely affect people from designated groups, what measures it's going to take to further diversity in the workplace, how it will reasonably accommodate people from designated groups to ensure their equitable representation, what measures it's going to do to retain and develop people from designated groups, and measures to ensure the equitable representation of those persons at all occupational levels in the workforce. And this is all generally included in an employment equity plan that the designated employer submits to the Department of Labor. So when it conducts its employment equity plan, it has to consult with all of its employees, it has to conduct an analysis, and then it has to report to the Director General on the progress that it makes in implementing its employment equity plan. So an employment equity plan would include the objectives that you want to achieve for each year of the plan, your affirmative action measures that you're going to implement. Importantly, it includes numerical goals to achieve equitable representation of suitably qualified people within each of the occupational categories in the work numerical goals, and then a timetable for which you're going to reach them, how long your plan is going to be enacted for, which cannot be shorter than 1 year or cannot be longer than 5 years, the procedures that you're going to use to monitor and evaluate the implementation of your plan, whether you've made reasonable progress in towards implementing your employment equity plan, what internal procedures you have to resolve any dispute about the interpretation or the implementation of the plan, who's responsible for implementing and monitoring the plan. Generally, a lot of employers have an employment equity committee and they they appoint a certain manager to oversee that. And now I'm going to deal, so that's a broad overview of the Employment Equity Act in terms of affirmative action. It also has general requirements to ensure that unfair discrimination in the workforce is prohibited. If you go to the next slide, please. So some of the notable and controversial amendments to the Employment Equity Act is the change to the definition of a designated employer. I'm also going to discuss in this presentation introduction of sectoral numerical targets and then compliance certificates that are issued for state contracts. Now, the definition of a designated employer, as I previously said, it's employers that have more than 50 employees, or if you have less than 50 employees, you meet a certain threshold of your annual turnover. In terms of the proposed amendment, there would be a deletion of the definition of a designated employer, which means that employers who have less than 50 employees will not be considered a designated employer, regardless of their turnover. So those employers who have less than 50 employees will not have to submit employment equity plans to the Department of Employment and Labour. And the intention behind this is to reduce the regulatory burden on small employers in relation to implementing their duties in terms of affirmative action. If you can just go to the next slide, please. Yeah, sorry, next slide. Then the next notable, and I think would be the most controversial proposed amendment to the Employment Equity Act, is the minister's power to set numerical targets. So the Employment Equity Act, as it currently stands in its unamended form, requires that where designated employers have identified underrepresentation of people from designated groups, so that's your Black people, women, and people with disabilities, it must determine numerical goals to achieve equitable representation of suitably qualified people in each occupational level in the workforce. So these numerical goals are contained in employment equity plans, and they're drawn up in consultation with employees. And it will include a timetable in which you set to achieve those goals. What the bill proposes to do is to empower the minister to identify national economic sectors and then to set numerical targets for any identified sector for the purpose of ensuring the equitable representation of suitably qualified people from designated groups in occupational levels. So what we currently have is numerical goals that employers implement, and what is coming is numerical targets that the minister is going to impose in specific sectors. And those sectoral targets may differentiate between various occupational levels, subsectors, and various regions. But prior to these numerical sectoral targets being imposed, the bill contemplates that there's going to be a consultation process. So I can go to the next slide, please. And this is where the minister is going to identify the national economic sectors and will set the numerical targets. And it has to consult with the relevant stakeholders and the Employment Equity Commission on the proposed sectors and sectoral targets that it's going to implement. So it contemplates that there's going to be a draft notice in the Government Gazette that's published, and then interested parties within that sector will have at least 30 days to comment on the identification of their sector and the proposed sectoral target that's being proposed for their sector. And to date, there have been some premature engagements that have taken place between the minister and certain proposed sectors, but the minister is not yet empowered in law before this act is enacted, before these amendments are enacted, to identify any specific sectors or to set any sectoral numerical targets at this stage. So practically what will happen is the minister is going to publish a notice identifying a specific national economic sector. It will consult with interested parties. It's then going to issue regulations prescribing the criteria that's relevant to determine what the numerical employment equity targets are going to be. It's going to consult with each sector. It's going to take advice from the commission, and then it's going to set numerical targets in a specific sector or part of a sector. You go to the next slide, please. So what's the impact of these sectoral numerical targets? In terms of the bill, there's going to be a requirement that any numerical goals, and you'll recall that I said earlier, presently, employers must set numerical goals. Those numerical goals must now comply with sectoral numerical targets that are determined by the minister. So sectoral targets are going to be linked to the numerical goals of the employer. It also proposes to include the requirement that sectoral numerical targets are going to be taken into account by the Director General when there's a consideration as to whether a designated employer is implementing the Employment Equity Act and their employment equity plan in terms of the Act. So numerical goals of an employer will be measured not only against the demographic profile of either the national or regional economically active population, it's also going to be measured against the employer's compliance with the sectoral numerical targets. And one critical consideration is the extent to which the proposed imposition of these sectoral numerical targets are going to undermine the significance of the requirement of the employer to consult with its employees or representative trade unions in order to determine its numerical goals. So if a designated employer has to take into account the sectoral numerical targets set by the minister when setting its own numerical goals, the consultation with employees and trade unions are pretty much going to be rendered meaningless, but it's still going to be compulsory for an employer to do. Go to the next slide, please. Then section 53 of the Act is not yet in force because the date of the commencement of this is still to be proclaimed, but it requires that in order to conclude an agreement with any organ of state for the furnishing of supplies or services or for the hiring or letting of anything, which is basically your state contracts, employers, so all employers, whether you're designated or undesignated, must comply with Chapter 2 of the Act, which is your prohibition of unfair discrimination. And in relation to designated employers, they must comply with both Chapter 2, which is your unfair discrimination chapter, and the affirmative action chapter in Chapter 3 of the Act. And then it needs to attach either a certificate obtained from the minister confirming its compliance with the Act or a declaration that it complies with the Act that is verified by the Director General. What the bill proposes to do is to add a further requirement to section 53, which includes whether the minister is satisfied that the employer has complied with any sectoral numerical targets, and if not, whether the employer has raised a reasonable ground to justify its failure to comply. What would constitute a reasonable ground is not yet determined. We don't know. There isn't any guidance in the proposed amendments at this stage. So that's something that remains to be seen. But effectively, failure to comply with section 53 and in effect, failure to comply with the sectoral target that's been imposed on your sector that you fall in is sufficient ground for rejecting any offer to conclude or to cancel any state contract that you may be a party to. So this is quite a notable change to the Amendment Act, but for employers that are not designated employers. So after the amendments are introduced into the Act, if you have less than 50 employees, you will automatically obtain a certificate of compliance in terms of section 53 without having to submit an employment equity report and without having to comply with the sectoral targets that are imposed by the minister. You go to the next slide, please. Can you go to the next slide? Go back a bit. Yes. So what about fines? Can an employer be fined if it doesn't comply with the numerical targets? So as the Act currently stands in its unamended state, fines can be imposed on employers who fail to comply with numerical goals set out in their employment equity plan. So that's not something that's new. And before a fine is imposed, there are specific enforcement procedures that are preceded before you're implemented with a fine. And it includes a review and a recommendation to the employer by the Director General in relation to compliance with the Act. And only if that recommendation is not followed, the Director General can then approach the Labour Court for relief, and the relief may include the imposition of a fine. So what the bill proposes is, when it requires compliance with sectoral numerical targets, if you fail to comply with the sectoral numerical targets, it is possible that you may be subjected to the imposition of a fine, but this would first be preceded by a review and recommendation before any fine is imposed. And also the Act contemplates that the employer is going to be given an opportunity to justify their non-compliance with the numerical targets, both before the Director General and then again before the Labour Court before any fine is imposed. If you go to the next slide, please. So consultations to date, you'll note that I stated earlier that there have been some consultations that have taken place by the Minister with certain sectors already prior to the amendments actually coming into force. And this seems to be the Employment Equity Directorate gearing itself up for the implementation of the amendments once the parliamentary process is finalized. So even though the bill hasn't yet been passed, the Department of Employment and Labour has been commencing consultation processes, which appears to mirror what the amendment bill is proposing before it identifies a specific sector and before it imposes a numerical sectoral target. So for example, we're seeing that the Department of Employment and Labour has already engaged in a consultation process with members of the wholesale and retail and trade industry, with the repairs and motor vehicles and motorcycle sector, as well as the accommodation and food activities sector. And it appears that these consultations commenced in October of 2018 and have continued up until last year. And during these meetings, it appears that the Department of Labour has been proposing the numerical targets that it wants to implement in that specific sector to be achieved over a 5-year period. And it seems that the proposed targets as they stand are mirroring the targets contained in the broad-based Black Economic Empowerment Act codes, so your BBBEE codes. And we're informed that the stakeholders engaged in those consultation processes have opposed the proposed numerical targets that have been submitted by the Department of Labour and have been given the Department of Labour their reasons for their opposition, which is specific to those certain sectors. So what we're having is, if the department does intend to use this consultation process prior to the enactment of the enabling legislation, arguably it could be acting ultra vires and unlawfully if it seeks to rely on those consultations. So what we do envisage is that once the Act is in force and these amendments are in force, we anticipate that the Department of Labour is required to again go back and consult with stakeholders. It cannot rely on these premature consultation processes that have commenced. And as I said earlier, the amendment bill envisages a multi-step process before a minister can set the numerical targets for a sector. So it first has to identify which economic sector it's going to be issuing a sectoral target for. It has to issue regulations which prescribe the criteria that's going to be taken into account. And parties need to know what sector is being consulted, and that has to be gazetted by the minister, and what is relevant criteria for determining a numerical target so that they can put forward relevant information for that consultation process. So it's possible, if the minister proceeds to issue a numerical target before the amendment bill is passed and based on the premature consultations, it's possible that this could be subject to review by our courts if any specific litigant wants to take that on review. And it is likely that this is going to be subject to challenge in our courts. So many stakeholders have participated in the premature consultation process to date. They've done it in good faith, but they have reserved their rights, and they have stated that they expect the Department of Labour to conduct further consultations once the bill is passed. Can you go to the next slide, please? And then the next slide. Oh, sorry, go back. So what about the constitutionality of these proposed amendments? This is quite a complex question and it involves a variety of considerations, but at face value, one particular aspect of the amendment bill does appear to be problematic. And it's the idea that sectoral targets would effectively override what the numerical goals are of an employer. And also, what does that mean for the consultation process that the employer has engaged in with trade unions and employees to determine what its numerical goals are? If an employer is bound to include sectoral targets that are fixed by the minister in its employment equity plan, consultation with employees and trade unions are going to be rendered meaningless because the employer's hands are going to be tied regardless of whatever input is provided from its employees. And there's no obligation on the minister to consult with any affected employees or any group of employees before fixing sectoral targets. So this may be some aspect for trade unions to get involved in when it comes to commenting on the publications in the Government Gazette as to what the proposed sectoral targets are. But this is going to be at a sectoral level and not at a plant level for a specific employer. So we're going to see potentially that there is going to be some challenge to these amendments. And another concern is that these sectoral targets may actually be quotas where an employer actually has to comply with it. It's no longer a goal, and quotas are specifically excluded as an affirmative action measure in terms of the Employment Equity Act. Some other amendments which are not as notable or as controversial is there's going to be a change to the definition of people with disabilities. It's going to include people with mental, intellectual, or sensory impairment, and in relation to their interaction with various barriers which may substantially limit their prospects of entry into or advancement in employment. So the proposed amendment seeks to align with the definition of the UN Convention on Rights of Persons with Disabilities. So for example, it includes persons who have certain limitations in their cognitive functioning and skills, including their communication, social and self-care skills. So this could be persons with Down syndrome or fetal alcohol syndrome, for example, would be included in the definition of a disability. A sensory disability relates to hearing and vision, or both hearing and vision, and the barriers that are referred to include, for example, your physical environment not being accessible or a lack of assistive technology. There's also going to be a removal of the requirement for psychological testing and similar assessments to be certified by the Health Professions Council, and that's because the council doesn't have the capacity or the procedures to undertake the certification. So the validity of those tests are going to be subject to evaluation by the Labour Court in the event of a dispute. Then there's a removal of the provision empowering non-designated employers to notify the Director General that they intend to voluntarily comply with the affirmative action chapter of the Act, as if they were designated employers. And it reduces the regulatory burden on small employers in implementing the Act. In terms of consultation with trade unions, if there's a representative trade union in the workplace, the employer is only required to consult with that particular trade union. And so some of the public comments that we've received so far is that the unintended effects of the amendments to the Employment Equity Act is that it is threatening existing jobs in a difficult economic climate. What is an employer going to do if its current workforce doesn't meet the sectoral targets and there's a specific deadline of, for example, 5 years where the employer has to meet that sectoral target? It could result in a number of retrenchments. And at this stage in our economy, that can be very difficult to find new employment and to find a suitably qualified workforce to replace your current workforce. There's a concern, the public have commented, and these are stakeholders within, it's Telcom, it's Agri-SA that have engaged in a consultation process with the Department of Labour when these amendments were proposed. And there's a very serious concern that these sectoral targets amount to quotas. And that's very likely going to be subject to legal challenge. There's also a concern that there's no clear guidance on what amounts to compliance with the numerical sectoral targets. So when can you provide a reasonable justification that you cannot meet a sectoral target? What is relevant? We don't know yet. It's going to override the numerical goals that are contained in designated employment equity plans. And how do employers in implementing these sectoral targets take into account regional and sub-regional demographic diversity and not just national demographics? So a blanket uniform approach doesn't work. There's no one size fits all for these targets, and it can cause social strife. And the last comment that I thought was notable from the public during the consultation process is that there's going to be a disincentive for foreign investors in South Africa because they won't have any prospect of qualifying for state contracts because they would need to comply with the numerical targets as they start their business in South Africa. So this adds additional compliance burdens for foreign investors. Go to the next slide. I think that's the end of my presentation. Thank you. So if you have any questions.
Okay, thank you very much, Melissa. We'll take questions now. If people could raise their hands. I can see, Melissa, that the EE, the employment equity, the government is trying to make it a law that will promote equity in the workplace, basically, and also achieve equality. Equality, as well as to eliminate any unfair discrimination, and most of all is implementing some kind of transformation. I can see that because it's long gone that workers had complained of the amount of payment that they get, and also I see they also after foreign nationals working in most of these companies. Okay, I don't know, Amina, are there any hands raised?
No, there's no questions.
Okay.
If anyone can post in the chat box as well, it's fine.
Okay, also, Melissa, I was thinking that, do you agree that this EE, employment equity, which is the legal imperative in a way, makes good business sense? What's your view on that?
I don't think the reason why the government is imposing these proposed amendments is for good business sense. I think the rationale behind it relates to the government's dissatisfaction with the current levels of employment equity in our workforce and seeks to address the inadequacies of the current employment equity plans, where numerical goals are simply just not being adhered to by designated employers. Designated employers submit their employment equity plans, but there isn't any reasonable progress towards reaching those numerical goals. And I think the Department of Labor seeks to implement sectoral targets to take a harder line on ensuring equitable representation of designated groups in the workforce. Whether that equates to good business sense, I don't think that is the consideration that the government is taking into account. And I think many businesses are going to struggle to comply. It does make good business sense for the definition of designated employers to change to only apply to large employers. So that's employers that have over 50 employees. Even with that, there's loopholes that can be created, and employers can, create various company structures to have, employees that are less than 50, just so that they don't have to comply with these affirmative action measures. So I do think equitable representation of designated groups in the workplace is a very important necessity in our constitutional democracy. But the manner in which the government is going about it is certainly going to be very difficult for employers to comply with. And I think there needs to be a little bit more room for justifications for non-compliance. It seems at this stage, it's quite unclear as to how an employer can justify non-compliance. Are employers going to be required to retrench majority of their workforce to meet a sectoral target because they want the compliance certificate to engage with government and get state contracts, which a lot of businesses rely on? So that's the answer. It's a bit.
Yeah,
I understand why the government implements it, but
I'm told also that it's there's a lot of concern from companies, on this thing. Yeah, tell me, what are the areas of focus? The main areas of focus.
What do you mean the main areas of focus?
Like, do they have a particular focus areas like, is it the BBBEs and transformation or the wage gap?
Yeah, it's not clear at this stage what their particular areas of focus are. What we've seen in the consultation processes to date, which are premature, is that the government is using as its benchmark the BBBE codes as its starting point to propose the sectoral targets for specific sectors. But we don't know yet what is relevant because regulations haven't yet been enacted and the specific sectors haven't yet even been identified. So it's unclear to what extent the government's even identified the sectors that it's commenced consultations with. Overall, it seems as if the government is imposing 5-year plans for companies to comply with, and it should mirror what the BEE codes are. That's where we're at the moment.
Yeah. Finally, I just want, do you think that this is the wrong time when government is mobilizing change in the country, especially like, I'm just trying to think about across all sectors, where we had this COVID-19 pandemic and it has really, they're still recovering. Owners are still recovering from the effects of COVID. So do you think it's the wrong time, finally?
Yeah, I mean, I wouldn't say there's ever a right time to advance affirmative action in the country. But in the consultation processes that have taken place to date, those have been submissions that have been made by businesses, that there has been a devastating economic impact on various sectors, particularly the tourism sector as a result of COVID-19, and to require these sectoral targets at a time when the economy is in a process of recovery and the recovery is not going to take place in the near future. This could be an impediment to economic development in the country. So it is a difficult time to impose these kinds of requirements. We don't know yet exactly when it's going to be assigned into law, and it may be something that is taken into account before the president signs it into law, because it could lead to some instability in the economy.
Well, I hope that doesn't happen, Melissa, but thank you very much for a very insightful presentation on affirmative action, equity, employment equity bill. And maybe once it's an act, you should be able to come back to us to tell us what has been dropped out as far as certain clauses. If we say there's negotiation and consultation with companies, are they agreeing with certain provisions, or it's imposed upon them? So it'll be good to have you once finally to give us the act and what has been passed. Thank you so much for your time.
So I see there's a question. There's a question in the chat box.
Oh, I didn't see that.
Someone has asked what for small businesses, what turnover is applicable for the designated threshold. So it depends what sector you fall under. It's obviously going to change once the amendments come into place, because if you're a small business with less than 50 employees, your turnover is not going to be relevant. But as it currently stands, if you look at 4 to the Employment Equity Act, it sets out agriculture, mining and quarrying, manufacturing, electricity, gas, and that all ranges for each sector. So it goes from 6 million up to 15 million rand, depending on what sector you fall in. So if you just have a look at the schedules, then you'll be able to ascertain whether you are a designated employer in terms of the Act as it stands today.
Yeah, it'll all depend on the numbers of employees. Thank you very much once again, Melissa. Thank you so much.
Thank you so much.
Bye-bye.
Bye.